Yeah, fiscal office. Also, I'd like to mention that 225 on behalf of Mr. Alia. This is difficulties. The lead counsel is in difficulties paid, so it's been about 3 weeks. Lordship may take without the adjournments yesterday also. Lordship the petition of the Grand Matrix on behalf of the Alia. Counsel for the other.
What is 26? Prayer is made on behalf of Mr. T.R. Learned Counsel for the petitioner for an adjournment in the matter on account of personal inconvenience. Prayer is not objected to by the Learned Counsel for the respondents. When?
After 3 weeks, my lords.
Last time also an adjournment was made.
Sorry,
Okay, then we'll have it after 2 weeks. 3 weeks, okay.
3 weeks.
Sorry. Accordingly, registry to list this matter again after 3 weeks on a date to be fixed by.
You're right. That is there. My lord, I take the decision item number 3. I'm not the reset weighted category of professional. That if you come up with 2 weeks.
Have it, you're for the petitioner?
No, my lord, I'm the respondent for 2. Joining us India.
And what have you taken consent from the petitioner? Have you informed the petitioner?
No.
Huh?
No.
No. Item number 12. It's a detention matter. You're not, you're for the Union of India.
Yeah.
We'll have the state, the records are here. Mr. Imsong, you have the records? You're not there.
Affidavit has been filed.
State has filed the affidavit, yes.
It is only being that material is there. The only thing that he has filed an application, that much only, nothing else.
We'll take up detention matters. We cannot adjourn this. Sorry.
I didn't practice. I did not set the administration yet.
Okay, fine. You're for the central government.
Yes,
State has also not filed an affidavit here. Mr. Counsel, state has also not filed an affidavit.
And my lord, the letter was supposed to be listed on 2805, not 29.
Okay. 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 It is there, an order is there. Just give me that file. 13. Oh, it's 25.
Yes.
205 today. There is a typographical error. Sorry. Okay. It is submitted that although the notice issued in the matter was made returnable on 28/5/2025, however, by the order dated 13/5/2026, however, typographical error has occurred in para 5 of the said order, wherein the registry was directed to list the matter today, that is 25/2026. We on perusal of the order finds that the direction for listing the matter today was on account of a typographical error. Accordingly, registry is directed to list this matter again on 28/5/2026. Sorry, it's a typographical error. Missed up.
May I please, Your Lordship?
Yes, madam.
Your Lordship, may I be pleased to mention item 8, Your Lordship?
Item?
Item 8. I-8, Your Lordship.
Hmm.
Your Lordship, if it is better, can come up after 3 weeks, Your Lordship.
Why?
I have to get properly instructed, Your Lordship.
Matter is already admitted.
Item 8.
Hey, Albert, give me item number 8. Madam, you are for the appellant.
Yes.
And you are appearing for? Madam, you are appearing for?
For the respondents.
State
For the respondents, Your Lordship. I want to file, Your Lordship.
Affidavit. Well, in an appeal, what affidavit do you want to file?
No, Your Lordship, I am for responding for 1 to 5, Your Lordship, but Your Lordship, I am yet to get properly instructed, Your Lordship. So another 3 weeks will be.
It shouldn't come up for, let it come up for hearing.
A prayer is made on behalf by Miss I. Zumi.
No, Livika V. Simi.
Lipika, learned counsel appearing for the respondent's number. Madam, for
1 to 5, Your
1 to
Lordship.
4 for an adjournment in the matter.
Respondent for 1.
Respond number 4. Respond number
1 to 4.
1 to 4. 1 to 4 for an adjournment in the matter to facilitate completion of instructions by her. So we find that this court-wide order dated 22/4/2026 has already admitted the appeal. The parties to the proceeding being represented, registry is directed to list this matter for hearing. You want 3 weeks time?
3 weeks.
Okay. After
Yes,
3
Your
weeks,
Lordship.
on a date to be fixed by
Much obliged.
Please, Your Lordship. But to mention for listing of an unlisted motion.
what is the
It has been filed this morning.
what is the
Episode of Your Lordship. Period of detention.
get it? It is proposed.
May I please, Lordship? Lordship, I beg to mention item 19. On behalf of my senior Mokam Lordship, for respondent number 3. Your Lordship, my senior is indisposed because of medical emergency. So this matter, this is the previous Lordship.
You are making this mention on behalf of Mr. Zamir, Moa Zamir.
Mokam, for respondent number 4, Lordship.
Okay.
Lordship, I filed my Bakalat Nama on the previous submission, but name has not.
No, your name is not reflected. Just give me that file. Item number 19.
We allow it by dismissal.
So there's an IE, what is this, condonation?
Condonation.
There is a private testimony also.
John. A prayer is made on behalf of the respondent number 4. Learned counsel for the respondent number 4 for an adjournment in the matter on account of personal inconvenience. Prayer is not objected to by the learned counsel for the applicant. Accordingly, registry to list this matter again after 2 weeks on a date to be fixed by reflecting the name of Mr.
Mokam, Lordship.
Mokham, learned for the learned counsel as the learned counsel for the respondent number 4.
Last Lord.
Please, Lordships, I'd like to mention item number 7. My Lord, here in this matter, we don't wish to file an objection, so if this matter can be fixed for hearing.
It's already admitted. The matter is already admitted. Let it reach, ma'am, we'll see. Let it reach, we'll see. Let it reach, we'll see.
You will upon the respondents have not been issued. So they will find amended thing, but the appeal is already admitted.
Please, Lordships, I brought the most item number 32 hearing. I believe that this matter may be adjourned for 3 weeks.
Life imprisonment.
Please, Lordship.
Boy,
We're challenging.
he is enjoying behind the bars. He's liking it. On the prayer of the learned counsel for the appellant,
Yes, Lord.
matter stands adjourned for 3 weeks.
3 weeks.
3 weeks. Registry to, matter stands adjourned for 3 weeks. Registry to list this matter immediately on conclusion of 3 weeks from today.
There's motions.
It's my lord, my lady. Back to mention Article 28. Well, here, I really will have difficulty, so they said, that's why I actually went just.
Oh, because this matter was listed for no other purpose because it was registered initially as criminal appeal jail.
Yes.
It's an appeal against acquittal. So that was directed to be converted. So we have converted it. I think you were there last time when it was converted. No, not there. Okay. List this matter before any other bench without one of us, Madam Namli Kiribi. It's only because we'll have to regularize that.
Yeah.
Now it has been registered as appeal. So just a formal notice returnable. So.
Yeah, Mr. Rochi, I beg to mention argument item 23 and 24.
22 is already mentioned.
23 and 24.
Why?
My senior, the actual who is leading the case is in disposal. So please very much understand, madam.
Also, no, not pressing it. It's ready. The paper book is also ready. 20 years 4-2. And the POSCO matter 20 years. Why? Or you have enough time to have this argument. Okay, on the prayer of the appellant, learning counsel for the appellant, 2 weeks or 3 weeks? 3 weeks.
Let this know. Worships for item material 6. Allow us to make a joint prayer, Lordship. There is a difficulty to the Lordship. So if the matter can be taken up on third, Lordship.
Why did you make us read it? Last time also, this is that supervisor.
Yes, yes.
We fixed it as per your prayer today.
There seems to be some technical glitches, Lordship. They were okay, Lordship.
Many times. No, last time it was there. He couldn't come, so we fixed it today as per his convenience. Okay. A joint prayer is made by the learned counsel for the parties for an adjournment in the matter on account of personal inconvenience of the arguing counsels. So accordingly, a registry to list this matter again after 4 weeks. After 4 weeks on a date to be fixed by.
The main sessions of the 2 weeks long. No sessions.
You are the appellant.
I am the appellant.
What is the error there?
The
The learned single judge has gone to the very essence of the matter. You have got your things from as per the old rates.
Here, besides the principal contract, 3 additional works were awarded. Now, later on, the rate was revised by the central government. Now, I have also completed the 3 additional works. After completing the 3 additional works,
There is a suit also pending.
no,
It's withdrawn.
yes, it was withdrawn on the assurance given by the union. Then I will be given a revised rate.
Yes, what do you say?
I don't know instruction. So need to note.
It seems that the Union of India is not very prompt in giving instructions here. That's the prayer I'm getting all along.
Yes, my lord.
Okay, we'll give you one more date. No further adjournments.
Since
No. We'll change it to 2 weeks, the normal course, on the prayer of Mr. MT Learned CGC, younger voting, Learned CGC, appearing for the respondents. The matter stands adjourned for 3 weeks as a last chance to enable him to complete his instructions in the matter. No further adjournment shall be granted. So, registry to list this matter immediately on conclusion of weeks.
Yeah, all readings are ready.
This is that order wherein that repetition was rejected because there was a delay in approaching the red court. What do you say on that? The learned single judge has, it's a plausible, it has been taken. In an intra-court appeal, why should we now come in and disturb that position?
There is a single catch.
See, the learned senior counsel, Mr. Yangote, is very much prepared. We'll hear it. He's very much prepared. We'll hear it. We'll hear you, sir. We'll hear you. It will be doing an injustice to him by adjourning the matter. See how prompt he is. We'll hear him today. We'll see them.
But it's item number 1.
Hmm.
I have received the hard copy, but I have not seen the original signed copy of the agreement. So I will give another full stand.
Item 1.
Item 1 is different. It's a PIL.
Yes.
Okay. There is an IT here. Who is for NHIDCL? What do you say? Have you filed a affidavit here? Affidavit. And you're for the union?
You know, I think directly to follow like additional activities on the property. I have received the same copy.
Okay. Okay. Mr. Yangalvati, learned CGC submits that the additional affidavit directed to be filed in the matter by this court is ready
Yes.
and would be filed within
Second was sent by post, so I don't know. 2 weeks.
within 2 weeks from today. Also, in view of the above, the in view of the above, the matter stands adjourned. Registry to list this matter again on 3rd of June, 3/6/2026. The affidavit on the additional affidavit be brought on record by the learned CGC on or before the next date of listing.
For admission, item number 2.
There is some data placed on the last occasion. It has all the elements, so we want to keep correctly.
May I please, your lordship? Lordship, before my learned friend submits, lordship would like to take you to order dated 18/3/26.
You were supposed to place the rectified facts.
Rectified was the lordship item order dated 13/5, but before that, there were 2 orders, 18/3/26 and 29/4/26, lordship. If my lordship may produce the order dated 29/4/26, lordship, in terms of affidavit that we have filed, providing the details of the clear claims with respect of all the hospitals, lordship, the respondent number 4 state was ordered to make an inquiry as to whether the MPNL hospitals have received their respective claim amount And for that, he has been directed to file a
Who is
compilation.
for respondent number 40? Huh.
Plus, in fact, and last, there was a coordinate by this on regarding the no tallying with the figures.
Mm,
Now, in addition to the company of the justification we have. Now, why the figures are not tallying, Lordship? Lordship, can you come to the no part? No part, Lordship. Submitted claims. So when the question of submitted claims comes, then the approved claim plus the rejected claim, plus the claim pending for at hospital, plus claims pending at the processing payment. So submitted claim includes all this portion.
Now, what is the claim amount pending with the company, insurance company?
Lordship, that one I have.
Sorry.
17 crore. Lordship, can you come to the
10 lakhs, 85,847.
yes.
So these are claims which have been passed by you and placed before the insurance company for payment.
No, Lordship. The system is solved. Now, the insurance company, we don't have a track record in the hospital. We, the state health authority, make an agreement with the hospital that you will be under the hospital for the two schemes. And an agreement also made between the state health authority and the insurance company.
Okay.
Now, the claim will be made by the hospital directly to the insurance company.
Okay.
We are there to monitor.
Okay. So you mean to say that 17 crores odd is the claims made by the hospitals pending with the respondent number 5?
Yes.
Yes.
Lordship, we have filed our detailed list, compilation of.
No. What do you say about this list that has now been brought? You were here last date.
Lordship.
So they say around 17 crores, 10 lakhs is pending with you.
Lordship.
What happened?
Lordship, out of those claims that stood rejected, Lordship, there was some office memorandum, Lordship, and there is a manual, Lordship.
Okay, Mr. Abhijit, you do one thing.
Lordship.
Ask the respondent number 4's counsel to give you a copy of this data that they have now compiled.
Yes.
Lordship.
So file an affidavit with regard to the compliance thereof.
Lordship.
Regard to the status thereof.
Lordship.
You give him the soft copy. Yes.
Lordship.
Lordship.
Hospitals, the Nagaland Doctors Association. Lord, on the basis of this information, we may also have to file a necessary affidavit to clarify our stand,
Okay, please do so. Please do so.
Because ultimately it's the claim.
It's their claim. So now, as far as we are concerned, your projection is around 17 crores odd is receivable from the insurance company by the empaneled hospitals. So you give him that so that he can.
Yes,
Mr. N. Mozik, Learned Standing Counsel, Nagaland Health Protection Society, that is the respondent number 4, has placed the data compiled with regard to the claims raised with the respondent number 5 and the amount and the claims so cleared by it. From the data, it is seen that an amount of rupees 17,10,85,457 pertaining to 4,743 claims raised with the respondent number 5 is pending processing.
Right.
So the said data having come on record, the court requires the learned counsel for the respondent number 4 to share the same with the learned counsel for the respondent number 5 and the other counsels appearing in the matter. The learned counsel for the respondent number 5 shall on the basis of the data now placed on record by the respondent number 4, file an affidavit with regard to the pending, the stage at which the claims projected to be pending with it is presently a stage at which the processing of the pending claims is presently situated. So let the said affidavit be filed within a period of 2 weeks will do, Mr. Abhijit?
Lordship, 3 weeks, because
3
it
weeks
has to come
from
from
today.
by Lordship.
3 weeks. The other respondents are also granted liberty to bring on record their stand, basing on the disclosures made with the data as compiled by the respondent number 4. Also, registry to list this matter again after 3 weeks on a date.
Lordship, any date may be fixed, because next time I will be coming down. Any date, Lordship.
Okay. Today is 21, 2, 3. On 17.
17 June.
17.
Obliged, Lordship. Deeply obliged.
For admission, item number 4.
I received verbal instructions from the state respondents. Only need instructions and comments to be sent for filing under the David is on the process. 100%. So may I claim a 3 weeks time to file
Okay. Who is appearing for the
What about union?
Lordship, I am appearing on behalf of the petitioner.
petitioner?
Yes, yes. Your
1 to 6 is represented, but you had taken steps for service of notice upon 7, 8, and 9.
Lordship.
And that notices were sent on 3/3/2026. There is no receipt thereafter, no acknowledgement. So do one thing, take fresh steps for them.
Lordship, in the meantime, your Lordship, as I stated at paragraph 7 of my petition, that is paragraph 8, I had also filed an RTI regarding whether this concerned department has floated tender or not.
And that they will get the instructions, don't worry.
Lordship, I just want to bring it to the knowledge of the Honorable Court that on 7th May 2026, I received the reply from the concerned department.
File an addition.
Lordship, I think definitely, even I was thinking to bring that reply on record, but I guess that state respondent definitely they will file this reply. Lordship, as per their reply, they are saying that they have floated this tender, but at the same time, along with the RTI reply, they have not furnished any documents.
Okay, fine. Whatever is there, you have received instructions. Bring it on record, we'll see.
Lordship, in the meantime, I have an interim prayer, and what I heard is that in some districts already construction work is going on.
Okay, we'll see. We'll see if anything is going on. We are here. We are not powerless. But you get this notice part cleared. Seen the office dated 18/5/2026, which reveals that the service of notice upon the respondent number 7, 8, and 9 is not complete. It is seen that the notices on the said respondents were issued on 3/3/2026. So accordingly, considering the long lapse of time occasioning since the issuance of notice to the respondents number 7, 8, and 9, the petitioner is directed to take fresh steps for service of notice upon these respondents number 7, 8, and 9 by speed post, steps within 2 working days from today. The registry to list this matter again after 4 weeks. In the meanwhile, the respondents shall invariably bring on record their stand by way of filing an affidavit.
For admission, item numbers 5 and 6.
That means noted. Just received the instruction only 2 days back. So we are not 2 weeks time.
No, that's the only thing we are doing.
Yes.
From the word go, giving the government time. It's a serious issue.
Yes.
It's a real serious issue. And we will proceed in this matter only after the stands of all are brought before this court. Otherwise, this may have a very big tsunami. I'll call it a tsunami. So, Mr. Imsong, please expedite this. And this is the last chance we are giving you.
That would be appropriate because the same submission is.
There, it's there. And see, this court had limited the issue to a very narrow compass. You only got to answer on that. Whether they are also required to give that historical documents, that's all. Now, I think it's in the favor of the state because the issue has now been narrowed down. We can't go beyond this. Also, I heard Mr. C.T. Jamil, learned senior counsel. There are two PILs, huh? Item number 5 and 6. And Mr. T. Masa, learned senior counsel, along with, heard Mr. C.T. Jamil, learned senior counsel, appearing for the petitioners in PIL number 4/2025, and Mr. Takamasa, learned, you change the order, huh? Takamasa, learned senior counsel, appearing for the petitioners in PIL number 2/2026, and Mr. C.T. Jamil, learned senior counsel, appearing for the petitioners in PIL number 4/2025. Mr. I. Imson, learned additional advocate general, appearing for the state respondent, submits that the instructions in the matter has already been furnished to him by the state respondents, and an affidavit incorporating the said instruction, basing on the said instructions, would be brought on record on or before. On or before, Mr. Imson, when? On or before 10/6/2026. No further adjournment shall be granted for the purpose. In the event the affidavits are not brought on record on the next date of listing, this court, in the event it finds it so necessary, shall require the personal appearance of the competent of the respondent authorities dealing with the matter to be personally present before this court on a date to be fixed for the purpose for assisting this court in disposal of the present of the above noted PILs. Registry to list this matter again on 17/6/2026.
For admission, item number 7.
We could just see.
Office order dated 2/4/2026. This honorable court has given the liberty to the respondents to file objections. My minutes here in this matter, we don't usually file for objection, so if this matter can be stood for a period of 2 weeks.
You are, madam, appearing for the writ petitioner. Respondent writ petitioner.
Yes, sir.
How can you be given a scale of pay? That's the issue.
Yes, ma'am.
You are entitled to the minimum of the scale of pay in terms of Jagjit Singh. How can you be given a scale of pay? The government of Nagaland would have to close shop then, if everybody is to be given an ROP scale of pay. Mr. Jamir, is that the formula you follow here? That all the ad hoc workers are also given a scale of pay? I don't think so. That's the intent of a revision of pay rules.
Should I serve as conditions not?
Hold on, they're given.
Yeah, please, Lordship, let us point instead to give the scale of pay to the whole co-chairs.
No, as per the old ROP, isn't it?
Yes.
So they are also getting the scale of pay.
Yes.
Then how can you?
They are already enjoying.
Then how can you deny them the revisions?
No, my lord, 1993 they are enjoying. But the Supreme Court has directed that to give the 2017 ROP.
No, if you are
2017 ROP is for the regular employee.
No, if you are getting a scale of, if you are giving them a, that was my misconception. My sister has now clarified that. Yes. Yes, clarified.
My lord,
If you have given them a scale of pay, the revisions automatically follow.
yes, my lord, after 1993 there is 1999 ROP and 2010 ROP and 2017 ROP.
I think I passed an order sitting singly.
Yes, my lord.
So,
And the latest one is 2017 ROP and it is only for the regular employee. My lord, Jagjit Singh case is very clear that minimum scale of
no.
pay.
Here the question is different.
Minimum means
Here
that-
the issue is different.
Yes.
Here they were given a scale of pay. Forget the ROP. They were given a scale of pay, right?
Yes.
When they were appointed, they were given a scale of pay.
Yes.
That authorization has not been modified.
Yes.
So how can you keep them in that scale of pay? Any revision occasioning will occasion to that scale of pay also.
And my lord, in order to say like, to come under equal pay for equal work, to apply the principle.
Need not be, need not be. See,
Yes,
that
my lord,
Jagjit Singh
Yes.
case is a case of fixed pay employees.
Yes.
Not a case like the respondent here who was getting a scale of pay. Now, if he is getting a scale of pay, the other consequences is a normal. No need to go to Jagjit Singh also.
My lord, in the equal pay for equal work, the principle bottom line to the since the petitioner they are claiming, they have to prove that they are doing the similar duty.
Okay, they have proved that they have proved by saying that you have attached to them a scale of pay.
No, my lord,
Okay, I went by only by the nomenclature. Now you have given them a scale of pay. As a super, when he was appointed, he was given a scale of pay of 800-1475. Now, this is of 2003. So he might have by now got 22 increments. Where is he now? He has crossed that scale. Madam, at what stage are you receiving your pay now?
I don't get the matter fixed for hearing. Since,
Today, we are hearing. That was my doubt. That is clear now. So now I have no clue.
There's another thing. While issuing 2017 ROP, I think there is somewhere it says that it shall not apply
Yes.
to or something like that.
No,
Yes.
that's fine. It is a situation, but
in the ROP, it's clearly mentioned, my lord.
but there is something else also. Okay, on the prayer of the learned counsel for the parties registry to list this matter again on, shall I put it on second? On 2/6/2026. On the next date of listing, madam, you tell us whether you are receiving an increment. Okay. And by now 22 increments you might have received. You might have crossed that scale. Where are you now? How are you being paid? Just get that breakup.
From the supplementary cost list for admission, item number 29.
I think this case has a long history.
Correct, lord. Eight round. Two campaigns have been filed. By both the parties, campaign has been filed. Accordingly, 4 days in advance, I have sent copies to the respondents' counsels. Although the method is very simple, the respondents were capable enough to complicate the matter and then confuse them not to go. That's how 10 days. The measure.
We have not heard that submission.
Measure has not been concluded till date, and the problem lingers on emotions.
The selection committee that is there, the highest person there is an additional secretary. He cannot. So, yes, they run it has been to a conclusion. Selection post, most of them can be allowed. Even if it's a selection post, then must be a selection amongst the persons who are there. This is speaker and the governor. Speaker and the governor will take care of this. But the thing is, that we something.
Mr. Jameen, now that the parties are before us, nobody else is to come, we can take up this matter for final disposal, subject to what Mr. Senior Counsel, Mr. Massa says. The one query, the learned single judge has come to a conclusion that this is a selection post. The rules for the purpose of promotion has a committee. That committee, unfortunately, the topmost person is an additional secretary. So the conclusion was drawn that maybe that committee cannot be this. But my query to both the learned seniors and Mr. Learned Senior here is that even if it is a selection post, there has to be a selection. Who has made that selection and what is the parameters applied for that?
The solution is.
You will say there was no selection. Yes, Mr. Masa.
That is wrong. Lordship, in the rule itself, the solution is provided under Rule 19. The Speaker has a discretionary power in exceptional cases because Lordship.
To create posts to provide for, that is the power.
Then the single judge gone wrong is this. What Lordship is saying is, I accept that. Since it is for this consideration of promotion to the post of secretary, and secretary is the chairman of the committee in the TBC, and it will be considered among the senior most officers. So, two additional secretaries. One is regular additional secretary, the other one is upgraded and appointed personal to the endowment. Let us assume that these two cases are to be considered. Then in that case, and who is also a member of the committee as per Rule 15. Then in that case, the committee will constitute only from the rank of joint secretary. Therefore, how such a junior officer can consider the cases of senior officers for promotion. That is how the learned single judge was convinced by the respondents. Now,
yes,
that is the whole confusion where the judgment went wrong. But Lordships, Rule 12 is the power of appointment. Rule 11, 12 gives interchangeable because there are 2, 3 amendments are there. But let me say Rule 12. To avoid any confusion.
12.
And Rule 15, that is with regard to the constitution of division.
Promotion committee.
Now, under the rule
12.1, it's the secretary and additional secretary is by the governor. And the other posts are by the speaker.
Gotcha.
Now, normally as we understand a selection post, here seniority is of no issue. It's only the merit. It's only the merit. There would be a cutoff somewhere in that service that people above this would be considered.
The word selection is brought by the respondents. Law is silent about selection.
Okay, let us assume that there has to be some.
My answer to your lordship's query is, which provisions of the service law says that the post of secretary should be a selection post?
It's not provided.
It's not there in the law.
Okay,
Number one.
We'll come to that.
Number two, by which law? Rule 15 has been taken away. Now, under Rule 12, because the contention of the respondent is saying that under Rule 12, appointing authority is the governor, under recommendation of the speaker, with prior consultation of the chief minister.
No,
Therefore,
Mr. Jamil, just
it has relevance to come to that conclusion. It has relevance. So in the rule, since there is no mention about the consideration by the DDC, it is a selection post. That is the interpretation. Except in your condition, come to clause 2 of Rule 10. Rule 10, the speaker will appoint for all the posts. That will be possible only when the DVC recommends the cases of officers who are fit and eligible to be considered. After selection, the appointing authority will appoint. That is what they have been doing all these years. So, accepting their condition, going by that, how Rule 12 can be read in isolation. After selection is done, under recommendation of the committee, then the governor will appoint.
This committee in 15 cannot consider the case of the secretary. Who is appearing for the speaker? Sir, you are appearing. How was the selection made by you?
The lordship matters to put submission. Authorized the appointment of secretary is not to use the government Rule 12. Rule 12 the lordship It not only provides for the appointing of the usually governor, but it also provides for the procedure, the manner in which the secretary is.
What is that manner?
The manner is on the recommendation of the speaker in consultation.
Okay. How is the speaker recommending, will make that recommendation? He cannot make that recommendation on his whims and caprice. There has to be certain norms for that also. What is the norms you have followed?
Now, that will be your worship. May I take the worship to do? Your worship is actually this selection post.
For the time being, let us hold it that it is a selection post.
Now, unlike in this, where the committee member has to make assessment of the case.
We are not even concerned, Mr. Senior, we are not even concerned with that. We want to know that the speaker had 4 or 5 choices before him. This is not a tenure appointment. This is an appointment under the rules. It tantamounts to a promotion. Now, there are 5 people. How has he decided? Let's say he has the power. We give it to him. How has he picked up X or Y?
Your worship, it is the post of secretary of the Nagaland District Assembly, the worship. Is a sensitive post. Now the speaker will recommend someone who is in his confidence.
But how? How?
Now,
If it is a selection post, then there has to be an assessment of merit.
their performance report, whatever is there.
Where have you made that examination? Have you filed an affidavit before the learned single judge? Have you therein specified that this was the procedure we followed?
I guess.
Because see, you cannot make any selection without there being a norm for that selection. A norm has to be laid down. We give you that because of the ambiguity in the rules with regard to the procedure, you can use the powers under the relaxation clause. We give it to you. There are Supreme Court decisions also in support of your case. But still, there has to be a benchmark somewhere. That, see, I have examined all, because you cannot deny him that. It's not because it does not give you, the rule does not give you the power to select somebody who is, okay, my PS. If I want a PS, I'm saying I want a PS or Chief Justice of our court. He can choose his PS, private secretary. For what? But we have a benchmark. That persons above this would be eligible to be selected as the secretary to the PS, to the Chief Justice. All these names, along with the biodata, their performance, everything is placed before the Chief Justice. He then selects. He then selects. So that is laid down. A procedure is followed. What was the procedure followed here?
In fact, Your Worship, in Rule 12, it is not been said in so many words, except for the fact that, except for saying that under the combination of speaker in
Issue rule, fix it for very strict from the thereafter and finish it. That's the work is also
For granting the current charge to the private respondent, speaker has invoked his statutory powers. Now, in my case, speaker is folding his hands.
Yes,
Second aspect of only one point. I am submitting lordship. Only one point. Even accepting whatever lordship has said, whatever respondent has said, it is a selection. Right. Even to consider her case for selection, she is not eligible. Why? Can we come to page 79? This is the last promotion appointment order of the private respondent number 4. She appointed with me at the same time, because on the basis of 7 advertisement, we were appointed in 1996. I was appointed as assistant research officer in the general cadre, and the private respondent number 4
Transport
was appointed in the transport cadre. And when by the saying of the respondents, roll got amended in 2012. That is how a distinction has been created. Okay, fine. Accepting their argument that 2 separate cadres have been formed in 2012. They have not challenged that, and thereafter,
she promoted 4 times, or 5, not promoted, upgraded the
Upgraded.
post 5 times, personal to incumbent. And the last promotion order, Lordship, you can see. This is the last promotion order,
79.
order, not promotion order. Can we come to office page 121? Page 121. This is order dated 30th May 2022. After the first writ petition was disposed of, that is WPC number 323 of 2021, on 12/5/2022. Within 6 days, they could amend the service road. Imagine, supersonic speed. And road was amended.
That's the power
eligible.
that's the power the executive has. We cannot question that.
I agree. But unfortunately, they could not amend the law so as to benefit that respondent number 4.
Okay.
They may have thought that this will benefit respondent number 4. Now, by this order,
We got it.
the earlier order of 30th November 2019 has been restored. And can you see page 79, which I have just referred to, last paragraph, the post will be automatically diverted to its original post of transport officer as and when the present incumbent vacates the post. So the post of senior transport officer as post of transport officer, after the upgradation, nobody has been appointed in this post. That means what? This post has been upgraded
Only for this. Only for this.
personal to the incumbent. And the moment she vacates, she will go back to the post of transport officer, which is equivalent to the rank of undersecretary.
Okay.
So, by Third Amendment Act, equivalent, merit equivalent, interchangeable. She is not eligible to be.
We will consider that.
Okay.
Now, the private respondent is continuing.
Yes.
Let her continue for the time being.
And the temporary officiating charge.
See that as it is today.
Okay.
Let her continue. Because the post of secretary is very much required there. We fix this matter now. All are represented. I think the pleadings are complete. Nothing more is to be brought. Only, sir, you will have to place the records before us. We'll have it next week or the week thereafter.
Next week.
Next week? No, it's a division bench matter. We will have it on 28th.
No, 27.
Is a holiday.
Session, from 27 to 30th and out.
Okay, then let us have it on 3rd.
Lordship.
On 3rd. Heard. Mr. Masa?
I have one additional prayer. If the appointment or promotion order of respondent number 4 is allowed to stand, then it will amount of allowing the illegality to perpetuate.
We are not doing anything because see,
even if that is suspended also,
Mr. Masa, we are not contemplating to pass any order against you.
even if that order is suspended also, the respondent number 4 will be holding the current charge on officiating basis.
We are
which
not,
he was holding the
we are
post
not,
for the last 4 years.
Mr. Jamir,
years.
Mr. Jamir, there is a adjudication by a court, right, wrong, we will see. But today we are not disturbing that. We are fixing it because the parties are before us. We are fixing it on 3rd for final disposal. Mr. Masa?
If that is so, because before the letters in the bench, this is a lost order and we go for expeditions.
That's it. That should be the spirit. 2 senior counsels and the arbitrator sitting in between. It will be an easy job for us.
Lordship, spirit is that if the matter is not heard on that day, then intent should be considered.
Okay, done. Heard, Mr. City Jamir, learned. Heard, Mr. City Jamir, learned senior counsel appearing for the City Jamir.
By I.M.
Assisted by Mr. I.M. Chan, learned counsel for the appellant. Also heard Mr. T.B. Jamir, learned counsel, appearing for the respondents number 1, 2, and 3. And Mr. T. Masak, learned. You are appearing for respondent number 4, learned senior counsel, assisted by Assembly Law, learned counsel, appearing for the respondent number 4. So, the learned counsel for the parties have submitted that the all the respondents being represented, the matter be taken up for final disposal on 3/6/2026. Mr. T.V. Jamil, learned counsel appearing for the respondents number 1, 2, 3, 1, 2, and 3 has submitted that the records pertaining to the selection made in respect of the respondent number 4 shall also be furnished on the next date of listing. Accordingly, the appeal stands admitted. Registry to list this matter for hearing on 3/6/2026. So, in the event on the next date of listing, the matter cannot be taken up for final consideration. The prayer for interim relief made by the appellant in the present proceedings may be considered by this court. So I can't force it because I'll not be. Registry to list this matter on 3/6/2026 for hearing. There are two caveats. Caveats stands discharged. The learned counsel shall be heard at the time of final hearing of the matter.
Submissions have been recorded in 7 paragraphs by the learned single judge. Not even a single line has been discussed. And my learned judge has also replied very well. I was very much satisfied with his reply. Not even a single line has been affected.
Mr. Jamil, that is why the division bench.
Yes, that is how we are visible.
But Mr. Jamir, for the speaker, you will have to show us. If I am there, I would have gone on that.
Last time the reports were produced. The reports were examined.
Okay, let us see that.
They are capable of doing it.
Oh no, wait, Mr. Jamir, this side they will not be.
If by manipulation we have succeeded in getting litigation, that for which, but then underlying litigation also, this is the real litigation. And other litigation, no all manipulation is succeeded because it's a record for sure. If that is so, then I have to.
No, Mr. Jamir, you would have to take them out together. It's just Mr. Jamir's way of putting it.
For orders, item number 9.
What I'm trying to submit is this now. This is been admitted, it will come up in the hearing.
Oh, we wanted to hear you.
As far as your query, I want to just,
No, it's okay. It's okay.
it should be listed for hearing.
Mr. Yamati, have you got the records? You have got the records? No, it's not before.
All the reports are also involved in the.
Okay, fine. You have that records with you. You have the records with you. Heard the learned counsel for the parties. This court-wide order dated 13/11/2024 has already admitted the present appeal. Also, Mr. Yangalpati, learned CGC submits that the records have also been received in the matter, and as further submitted that the same is also available in the records of the present appeal.
I also appreciate.
Okay. Also, accordingly, the registry to list this matter for hearing on. Sir, when?
Next week, after 2 weeks.
On 3rd.
No.
3/6. Will be fine. 3/6/2026.
Well,
For orders, item number 10.
Email 277 days.
Lordship, this morning I filed my brother
For?
in IAP 51 to 52 and the WA 49
Okay, you knew about it.
for the respondents.
For the respondent, that means the wife of the original petition. You knew about it. You came up before this court in 28 by way of filing IA 28. Unfortunately, your name was not reflected. You are here. So there is a delay of 277 days.
Yes, Lordship, I may be given some time to file my objection
in alia 251.
Things that are not being done. See, page 5. Not the petition. Supreme Court now has said that this is a petition is not a ground for this properly. 5. There are 6. Is that explanation? There is no explanation.
As far as,
Do you know the latest decision of the Supreme Court which says that this sort of explanations will not be accepted? Nothing is there. What is that explanation? You just have said because of the bureaucratic processes involved. That is no ground for condonation of delay.
Since the money was involved also, there was a financial implication also.
Financial implication would be for compliance with the order, not for filing of an appeal.
And also that was put to the next fund.
Where are the dates? How was the file processed?
And from there also.
How has the file been processed? How can we discern that from your para 6? We can't. We can't. No. So, counsel, there has to be some plausible explanation.
At least some dates.
Some dates, how it went, how it were, who took the decision, why it was delayed. Just barely this, those days are gone. It's not the length of the delay that is material, the cause that you have shown. And a person is waiting for his pension. And I think the reason was this is that Dobashi's appointment, that one, that case. Khalasi, huh? He was a regularized employee.
No, lawsuit, no, lawsuit. The petition, the respondent was serving as a work cash on the fixed pay. And it was. And the respondent was.
How long did he work till his retirement?
35 years.
35 years. So he's covered by that 2015 circular.
But in fact, during the lifetime lawsuit, the respondent did not file any petition.
Okay, fine. He did not find this. He's only a Khalasi. He's not a well-read person. He may not know. You file an additional affidavit explaining the delay. Para 6 is not satisfactory.
No.
Madam, let them file an additional affidavit. The learned counsel for the applicant, after having attempted to argue the matter with regard to has submitted that he be granted further 3 weeks' time to file an additional affidavit towards explaining the reason for the delay occasioning in instituting the connected writ appeal. Prayer accepted. Registry to list this matter again after 3 weeks. Because there is nothing to file an objection to now. Let him file that additional affidavit, then you file. Okay.
For orders, item number 11.
Who is for the Bar Council? You are appearing? Yes.
The bar council was to file the order on the first affidavit. So then we will give something.
He will give you time till eternity, no problem. But 7th, the examination must be in Kohima. It should be in Kohima. The of Nagaland.
Proceed, I'm appearing for the response number 3, the Bar Council of Nagaland, Mizoram and Assam. So I have been instructed to file my wakalatnama.
So you file wakalatnama, you don't file wakalatnama, that's a different thing. But the earlier order directing for holding of the examination in Kohima must be complied with.
The examination has been conducted by the response number 2, Lord. We have no any involved in this matter.
Okay. Response number 2. Date is 7/6. We'll record your statement to that effect. Yes. Your name? We can dispose of the matter they are saying.
Yes, my lord. Just
okay, we'll have it after 7th. We'll keep it till after 7th, but we'll record her statement that it will be held here.
Through email and through personal control, the destroy permitted incidents of this knowledge for the purposes. So, out of these, there were 412 candidates. So, out of till 526, 51st to this candidates, they opted for Nagaland. So, if they are willing, if they want to attend Nagaland,
you have the exam in Nagaland for all the students who are residents of Nagaland, have it in Kohima. If any student wants a different place than that, it will be an option that they will give. Otherwise, why should the people from here go to some other state to hold the examination? They'll practice here. They'll have to be here. Everything has to be given. And these are small kids. You get my point? So it's safe for them, their family, everybody, and it's an examination. So let them have it with their open mind. Let it be here. Okay. In terms of the directions passed by this court-wide order dated 6/5/2026, Miss, your name? So and so, Learned Counsel has entered appearance on behalf of the Bar Council of India, that is the respondent number 2. Ms. So-and-so, Learned Counsel for the respondent number 2 on instruction submits that the direction passed by this court, wide the order dated 6/5/2026, to have a examination center for the All India Bar Examination 2026 at Kohima has been complied with, and the steps are being taken to have the said examination held also at a center within the town of Kohima. City of Kohima, town. It's city of Kohima. So, in view of the above submissions made by the Learned Counsel for the respondent number 2, no further order is called to be passed at this stage in the matter. However, this court would like to monitor the matter. Accordingly, the registry is directed to list this matter again on 10/6/2026, on which date the Learned Counsel for the parties shall apprise this court about the developments taking place. Also,
So
Madam, ensure that. Oh, Mr. A. Chetri, Learned Counsel, is present for the respondent number 3.
Yes. Obliged, highly obliged.
Orders, item number 12.
Item number?
12.
Records are here.
Lordships, the petitioner hearing is seeking for revocation of the application order dated 23rd January 2026. The approval order dated 02/02/2026.
Subject for something.
And the confirmation order dated 14.
I think those are there. If not, it is possible.
timelines have been met, I suppose, in this case. For detention, the issuance of orders, the sending to the government, sending to the central government, advisory committee.
No,
Not met.
no.
Oh, how? How do you say that?
The detention order was passed on 23/01/2026.
2301.
01/2026. And the government
2301/2026. Page.
detention order is page number 22.
22. Okay. Hmm.
The government ought to have placed my detention order, maybe the grounds of detention. If I submitted to the detention before the advisory board, placed before the advisory board constituted under section 9 of the legislature. Or before 14/02/2026. However, my lord chair, in the present case, the matter was placed before the advisory board only on 21/02/2026, which is after the expiry
Okay,
of 2 months.
okay. Let us go serially. 23/1/26 is the order of detention.
Yes.
2/2/26 is the order of approval.
And 14.
And when was it sent to the central government? It was also sent on the same day. 2/2. It was sent to the central government on the same day itself, I suppose. Map page 8. What is this page 8 of your affidavit, madam?
This is the reference to the advisory board of the.
What is the name of the detainee? Alote 6. Alote A. Alote A 6. So, madam, come here. It says date of detention order is 2/2/2026. But it is 23/1. This one. Okay. State government 2/2. Okay. Central government 2/2. 13/2. 14/2. 14/3. Give me the NSA. NSA. When was it placed before the NSA?
My lord, my quotation is not on 21/02/2026. 21/02. That is when the board said, and I was produced before the board.
So that is within 3 weeks.
No, my lord. Beyond 3 weeks, my lord. Detention order is 23/01.
Okay.
2026, my lord. So from the date of detention, within 2 weeks, the detention order, and only the terms of detention is to be placed before the advisory order. Proceeded under section 9 of the legislation. And this has been violated, my lord.
You mean to say that it should have come within 13th of
Yes, 13.
13 of February 26. 21 days. And the NSA, the order of it was placed before the. When did you make your representation in the matter?
1703.
Is the order of the authority, the board before us? Madam, it's there on record. Just. It's correct. The board had sat on 6-2. Yes, they had sent it 6-2, and sitting is on 21-2. No.
He said on 21-2,
But it was
sent on 6-2.
It was never placed before the advisory board.
That's not the requirement of the provision.
No, that is the requirement.
And you submitted your representation on 17-3.
Regardless of whether I submitted.
That is different, huh?
No. Regardless of whether I submit my representation of law, I can give it section 10. Regardless of whether I send my representation or not, the grounds, the order of detention is to be placed before advisory board.
Madam, where is the forwarding of the letter to the advisory board? Page? No, that is the forwarding of his representation. Before that, the grounds of arrest, when did you forward to the advisory board? Okay. This is the letter 6-2. Then again 17-3, they have forwarded this. So that timeline is, okay, this is the order. Advisory board 9-3. Madam, all said and done. Okay, we hold that the timelines have been met. No problem. But what is the material before you or the detaining authority to come to the conclusion that he will be released on bail? Your order does not reflect anything, but your grounds of arrest at serial number 4. Subject so-and-so is presently under judicial custody at Central Jail, Dimapur, and is likely to move for bail. Is that material enough to come to the conclusion that no, he will be released on bail? And he has not even filed an application for bail here. So what are the materials that you have relied to come to that conclusion?
What is the name?
Only content. Just go.
It's not this case here, the page 31. Initially, the first paragraph, it clearly stated he was arrested for carrying out kidnapping and abduction.
No, that is with regard to the nature of the offense. Now, that offense can also be taken care in the normal course. So, your apprehension that he will be released on bail and then he will again go back and do this, that what is the material? Were any co-accused released on bail? He had not applied
He
till
had
that
not
time.
applied.
He had not applied. So how did the detaining authority come to that conclusion? There has to be some material. Yes, what do you say on that?
That's one. That is my first ground. If I have to do it.
So where are the decisions in support of that? So timelines, Mr. Counsel, they have, I think, met, but this is the case of Nancy.
Nancy versus state of Nagaland.
Para?
For 15 members. Very good. For 15, then for 21.
That has 16 lost life. Twenty. Okay. We are retaining the records, but just take down their names. Madam, just give it to me. But so and so, so and so, so and so. Hearing concluded, judgment reserved. Even authorization to take the
Good. For orders, item number 14.
But the additional IA also, nothing is there. Have you filed any objection side?
Yes, nothing that.
Want to file an objection? No.
Nothing is there.
Which was some time in the solid dust. Then it was rejected. Then there was a litigation for December. So this is where we need to fight because of the notification. There's a delay of 60. Otherwise, there should be a delay of only one.
No, delay we are not concerned. Delay may be years together. But what is the explanation? Only para 8. Nothing.
I have found an additional affidavit.
Para 8 of the additional affidavit.
Not
Sorry. Or you have filed an interlocutory application. Interlocutory application number?
12 of 56.
12 of 26.
When did you file that additional affidavit, Mr. Yamaruti?
I will add on the basis of the direction issued by this court, FTM 2026 on the this IA.
Where is that additional affidavit?
5 of 74.
This is why it is affidavit in employment.
Okay.
So,
An affidavit in reply, additional affidavit on behalf of all the applicants.
yes, no.
Okay, that is para 8.
4, 5, and 6. Sorry. It is the order.
No. Para 5.
First, yes, yes. Then when you got Mr.
This is no reason.
Then what if paragraph page 6? Paragraph page 6. Then
I'm sorry. Can't be accepted. Nothing is there. These are just vague pleas. Where is that meat of the matter? That the file was here, file when they filed, then this. It was those are not there. Sorry, we can't accept this.
Proper dates are not there.
Nothing is there.
At least.
That cannot be the reason for delay. You must know.
I don't mention the date, I only mention the.
No, you have not even mentioned the stages. So from this period to this period, it was here, from here to here. What was the reason why it was there? It has to be. Now it's the law is very clear. Sir, you have the latest decisions of the Supreme Court on this point?
And I think that you're looking forward. Page 8. It is reflected at all. Just about the week, I know, study is use of browser. Decision of something in the browser validation.
Mr. Gauhati, you were there in that earlier case referred.
Yes, I was also
Responded. Okay, we'll not put you into trouble. We'll give you some time, but not satisfied. Give you some time. Let it. But the Learning Council for the parties on the prayer of the Learning Council for the applicant, registry to list this matter again on when after a week on 28/5/2026.
Petition is not there on 27, so I put it on 28 in the other cases.
For orders, item number 15.
Steps have not been taken in the form of the briefs.
Notices was issued
Steps.
Steps taken by
when
on the third of April.
but they raised who took?
Pardon, members.
No, did you take the steps on your own?
Yes, madam. In the third April. In the 3rd March, sorry.
No, you have not taken the steps through the registry.
I'm confused, my lord. I personally took the trouble on the 3rd March, through speed post.
No, routed through the registry. Because the registry note says steps not taken.
You have gone and sent the notices straight to the respondent number 2.
Sure, my lord, I'll see to it. I need to give me some time.
You take steps through the registry. Seen the office note dated 18/5/2026, which reveals that steps for service of notice upon the respondent number 2 has not been taken. Also, the Learning Council for the petitioner submits that he had on his own taken steps for service of notice upon the respondent number 2 by way of speed post. However, he submits that he would take fresh steps through the registry for service of notice upon the respondent number 2. Prayer accepted, raised a petitioner to take steps for service of notice upon the respondent number 2 within 2 working days from today. Registry to list this matter again after 4 weeks on a date to be fixed by. You take it through the registry.
For orders, item number 16.
Well, the matter is listed for the first time in the matter. In the internal prayer, my lord, I am praying for a delay combination of 830 years in filing the unintended privilege, my lord. This is a legal services matter.
But there is a respondent.
Yes, my lord. My lord.
Private respondent, that respondent number 2, POSCO matter.
Yes, my lord.
So we'll have to issue notice. You are the additional public prosecutor. Public prosecutor. The present interlocutory application has been instituted, praying for condonation of a delay of 830 days in instituting the connected criminal appeal. Also, issue notice returnable 4 weeks. Mr. So-and-so, a public prosecutor accepts notice on behalf of respondent number 1. Also, the Learning Council for the applicant to take steps for service of notice upon the respondent number 2 by way of speed post steps within 2 working days. Registry to list this matter after 4 weeks. Okay. It will take steps for service of notice upon the respondent number 2 through the jurisdictional police station by routing the said notice through the office of the public prosecutor, Gauhati High Court, Kohima.
For orders, item number 17.
Similar orders were kindly to pass. This is also a legal services matter. Here I am praying for the authorization of delay of.
955 days and respondent number 2. Okay, same.
This one.
For orders, item number 18.
My lord, this is another legal services matter.
Same.
Yes, my lord. There also respondent number 2,
Also, same order.
my lord.
Kali was it? Same. Kali 271 days.
From the supplementary cost list for orders, item numbers 30 and 31.
Why is the names not being shown? Why is the names not being shown here? It's only in material. Postco the respondent's name in there. But here, none of them. Why is the accused name not shown? He's around 35. Can you just ask the registry why these names are not being shown? Because everybody, it's them. I mean, around 35 years.
Medicine laws.
Oh.
All of the also fees the big. Some of sentence for 2 years. It's also on the court to an appeal. And only that bail will be filed. And before the appeal, there's a delay of 1,048 days.
We'll issue a notice now.
Slaughter.
Same. Ali Nam Gita Budli. Public prosecutor, respond number 1.
The copies.
We'll put his name only. Public prosecutor, respond number 1. Steps on respond number 2. Same, huh? List after 4 weeks. 31 ekalage jabo order to hobo IA criminal
Slip an extra copy, service copy.
service copy. We have put your names
Yes, sir.
and we'll ask the registry why the names are not being reflected because it's only the victim's name that has to be not disclosed.
Yes.
But the accused name has to be put bold.
For hearing, item numbers 20 and 21.
That is, process, we allowed to make one submission of. Or Worships have been appointed as a legal expert.
Your name is not shown.
Yes, and one more thing, I received the paper book a week ago. Allow me to just. Just produce the records. Yes, Worship, to effectively assist this work.
In that case, my lord, at least the bail application may kindly be considered because the appellant, he has been under custody for 7 years and 11 days. Then, my lord, if my criminal appeal is heard, this 11 days, it will, I believe, amount to illegal detention. Because, lordship, it's a very peculiar case.
Okay, we'll have it next week. Don't worry.
My lords, I thought,
Sentence is years.
my lord, it's a very peculiar case in that sense. Originally, he was sentenced to 7 years. So, he preferred an appeal before his honorable court. This honorable court directed that the trial be conducted de novo. Now, the same court, the same judge, sentenced after conducting de novo trial, the appellant to 10 years. Now, that is not permissible under law. Because the appeal was preferred by the appellant, by the country, not by the state or by the victim.
Okay.
Nothing.
The maximum 7 years.
He served
7 years, 11 days is on today of actual imprisonment without remission.
So with remission.
He has served more than 9 years.
9 years. Or we'll have to say that he's entitled for 10 years.
the instant application under bail in the this is IA bail application 21. Yes.
The bill here, open and stop, give another. And letters for now. The bill.
In the bail application,
Now, my only prayer at this stage is that let's put a law laid down.
wait. This is also POCSO.
Yes.
In POCSO and 376 matters, the informant has to be always implicated
Well, he's
in,
not been.
bail also.
On that solitary question, it's a pure question of law. Because
Okay, since
The next
is already
video-
She is there, so we'll say that
we
we'll
have
put it.
accepted the bail application also. No?
We'll put Tushi's name.
the next division bench, my lord.
No, this one. We are giving you
We
bail.
are giving you bail.
We don't want that. Next division bench.
The consent application under section 389, clause 2, read with section 437 of the CRPC, has been preferred by the applicant/appellant praying for release on bail pending the disposal of the main appeal. So, Parahard Learned Counsel for the applicant, Mr. Santianger. This is legal aid or
No.
not legal aid?
Not legal.
Also heard Mr. K. Angami, learned PP for the state of Nagaland, as well as Mr. Tushi Olonglemar, learned legal aid counsel for the informant. Informant? Yes, informant. Stop. Para. The case of the applicant herein is that the accused appellant was convicted. Where is that? Convicted under section 376(2) IPC, read with section 4 of the POCSO Act. In GR 49 of 2015, in connection with Agunato, AGHUNATO, Agunato PS case number 4/2015 by the learned, where do you say? Learned Session Judge in Boto, Nagaland. Stop. Para. Thereafter, the applicant filed criminal appeal number 1 of 2020 against the aforementioned conviction before this court. Is it? No, the earlier one. The earlier one.
Was stated
One of 2017.
19/12/2016, the judgment, and the criminal appeal is stated, criminal appeal is numbered 1 of 2017, 1K of 2017.
1K of 2017. Which was disposed of.
By order dated.
Where do we find that? Where do we find that?
Page
Page 92, the date is given on page 93, after paper book.
Oh, in the paper book.
Yes, my lord. There are 2 paper books, so paper book file 1.
File 1.
Yes, page 93.
Page 93.
Starts from page 92, the date is given on at page 93.
24/8/2018.
So before that, you say, in that convicted and then sentenced to 7 years. Okay, and sentenced to 7 years in prison. Then after that, you say against that, file criminal appeal number 1K of 2017, which was disposed of by an order dated 24/8/2018, thereby remanding back, back the matter to
The relevant
the
court is at
court
page 97, paragraph 12.
for a de novo trial in accordance with law. Stop. Para. The de novo trial was conducted as per the direction of this court in criminal appeal number 1K of 2017.
Page 123, convicted. 376.
The present judgment.
Is at page
Judgment.
98, the sentencing order is at page 98, which is dated 1/11/2019, and the conviction order is at page 99, which continues till page
123.
123. Conviction order is dated 30 October 2019, sentence is 1st November 2019.
This is it. This is the conviction.
The de novo trial was conducted and the appellant slash accused was convicted under section 376(2)(1) of the IPC, read with section 4 of the POCSO Act, and sentenced to sentence order.
Page 99.
That's 98.
Sorry, 90. Page 98.
And sentenced to 10 years rigorous imprisonment with a fine of rupees 10,000. With a fine of rupees 10,000, no default clause.
No default.
With 10 years rigorous imprisonment and to pay a fine of rupees 10,000. So, the learned counsel for the applicant submits that the applicant has now been incarcerated and has served and has already served
Actual imprisonment of 7 years and 11 days.
of 7 years and 11 days as on today. So it is also submitted that the applicant. You also said something about medical ground, no?
Any medical ground
Any
involved?
medical-
Yes, earlier, when the bail application was filed, but this case, yes,
None now.
yes, covered, yes.
So, in view of the above circumstances, facts and circumstances, the learned counsel plays that the appellant slash accused may be released on bail pending the disposal of the criminal appeal number 1 of 2020. So, is anything? On the other hand, the learned PP, Mr. K. Angami, has objected to the instant bail application and praised that the entire criminal appeal may be heard on merits. So, instead of allowing the bail at this stage. So, the learned legal aid counsel, Mr. Tushio Longomar, has also adopted the submissions made by the learned PP. So, we have considered the submissions of the learned counsel for the parties and perused the records. So, it is seen that in the earlier criminal appeal, number 1K of 2017, the learned single judge, isn't it?
Yes, learned single
judge had remanded back the matter for a de novo trial. So, in the earlier trial, the petitioner slash applicant had been convicted under section 376. Under 376 2 IPC, read with section 4 of the POCSO Act, for an imprisonment of 7 years. And he had preferred an appeal against the same. So, however, it is seen that in the after the de novo trial was conducted, the learned trial court has convicted the applicant for a period of 10 years under the same charges, is it? Under the same sections of law, under the same sections of law. So, it is also a fact, and it's also an admitted fact that the applicant slash accused has now been has now served out 7 years and how many days? 11 days
As of
of sentence. We are therefore of the view that at this stage, the applicant / accused is entitled to be released on bail. So the application is therefore allowed under the following conditions. The applicant shall execute bail bonds for an amount of rupees 10,000 with one surety of like amount to the satisfaction of the trial court. Number 2, the applicant / accused shall not leave the jurisdiction of the trial court without permission. That is
Itu perform on my dividend.
bail is disposed of.
Bail disposed. Application disposed.
For hearing, item number 27.
The qualifying years of service to get pension is 10 years. However, here the petitioner should be served only 9 years, which is 1 year short of qualifying years. However, the learned civil judge, he has counted all this contingency period and directed us to pay pension to the petitioner till his date, from his retirement till his date, and thereafter to pay the family pension to the petitioner's wife. Worship will come to the appointment order. That is at page of 41. Worship, it is order dated 18 August 1970. And the petitioner's name is at serial number 6. Petitioner husband. Sri Yalise Santam, NLC Channel. So initially he was not Dobashi also, he's only Nagaland National Corps on a contingency period. Then thereafter, by order delivered, page 43, this is order dated 10/6/1974. He was appointed as Dobashi on temporary basis, Proceed. Thereafter, he died he retired on
81.
1981, that is at age 49. He had got only at age 49. The second last para, on attaining the age of superannuation, legally says sometime interpreter breakthrough is hereby allowed to retire from government service with effect from 1/7/1981. Then the next page, 1950, he died on 16/9/2002. Page 50, he died on 16/9/2002. So now when he represented to the government, after a period of 26 years, the petitioner's wife, she represented to the government for pension. When it is declined, that is at page 17. Worship is that related
CCS pension rules.
11/7/1917. I mean, they love to read. To the Accountant General Nagaland, subject family pension fees in respect of late Ulysses Santana, retired DP interpreter under the establishment of Deputy Commissioner Nixon. I am directed to refer to letter such and such received from a letter on the above cited subject and to state that the matter has been examined in consultation with the Finance Department and to convey that the total length of service rendered by late Ulysses Santana is only 9 years, 1 year short of the minimum qualified service of 10 years to be eligible for pension. As such, the proposal program of pension is not covered under any extent rules. So the petitioner being denied of the pension, he filed the WPC number 312 of 2017 noted that by judgment in order dated 5/3/2004, this is at page 95. Page 95 is a judgment in order dated 5/3/2024. The learned single judge, the perversity that the learned single judge has committed is that the petitioner's husband died in 2002. However, the learned single judge said that the OEM 2017 squarely covered the case of the petitioner lordship. I may be allowed to read some of the paragraph lordship. Page 105, paragraph 17. There is no dispute at the bar that the state of Nagaland has adopted Central Civil Services Pension Rule 1972 for its employees. The contention that due to the operation of Rule 2C of the Nagaland Civil Services Pension Rule 1972, the said rules are not applicable to the husband of the present petitioner does not appear to be convincing, as at the time of the retirement from service on 17/7/1981, the petitioner husband was not a contingency paid Babashi, but was posted as paid Babashi in a scale of pay plus other allowances, and said appointment as Breakthrough Babashi was effective from 1 June 1974 against existing vacancy. Therefore, when the husband of the petitioner retired, therefore it would be wrong to say that the CCS pension rule, which has been adopted by the state of Nagaland, would not be applicable to the husband of the petitioner, merely because of the fact that in initial 3 years, 10 months of his service, he was paid from contingency. Rule 13 of the CCS pension rule provides as follows: commencement of qualifying service. Subject to the provision of this rule, qualifying service of a government servant shall commence from the date he takes charge of the post at which he is first appointed, either substantively or in an officiating or temporary capacity. Provided that officiating or temporary service is followed without interruption by substantive appointment in the same or another service or post. Provided further that A, in the case of a government servant in this service or post who held a lien or a suspended lien on a remaining pensionable post prior to 17 April 1950, service rendered before attaining the age of 16 years shall not count for any purpose and be. In the case of a government servant not covered by clause A, service rendered before attaining the age of 18 years shall not count except for compensation by 19. From above rules, it appears that the qualified service of a government servant shall commence from the date he takes charge of the post to which he was first appointed, either substantively or in an officiating or temporary capacity. Though the petitioner was appointed by the appointment letter dated 18/8/1970 as contingency paid Babashi, however, his appointment was temporary in nature and was against a sanctioned post in the scale of pay with all admissible allowances. Therefore, it would not be wrong to say that the nature of service rendered by the petitioner from 1/8/1970 to 1/6/1974 was temporary in nature. It also appears that thereafter on 1/6/1974, he was promoted and appointed of grade 2 Babashi in a scale of pay against sanctioned post, and there was no break in service from the date of his initial appointment as contingency paid Babashi. And therefore, the first proviso given to be for example, Civil Service Pension Rule 1972 is applicable to the case of the husband of the petitioner, PT. As regards the submission of learned counsel for the respondent that 50% of the service rendered by the husband of the petitioner as contingency paid Babashi was taken into consideration for completing the qualified service as per the Government of India decision under Article 36A of the CSR rules as mentioned by the respondent in the affidavit in opposition. This court is of considered opinion that though the CCS pension rule have been adopted by the state of Nagaland, any decision taken by the government of India under the said rule would not be automatically applicable to the employees of the state of Nagaland unless same is adopted by the state of Nagaland. 51. In the instant case, the decision to take into consideration only half of the service of the employees who were paid for contingency for completing the qualifying period is not a part of CCS pension rules, but only a decision of the government of India. So, Lordship, is a very purpose here. The state of Nagaland is governed by its own office memorandum and rules and regulations framed by it or adopted by it. Merely because government of India has taken a decision in a particular manner, same would not bind the state of Nagaland when it has its own office memorandum to deal with similar circumstances. The respondent authorities are bound by the policy decision taken by the state of Nagaland and not by any decision taken by the government of India in this regard. Unless the policy decision of the government of India is adopted by the state of Nagaland. 22. It appears that though the office memorandum dated November 2009, which is relied upon by the petitioner, has been superseded by the office memorandum 2017, cited by the Learning Single Government Advocate. However, clause 6 of the state office memorandum dated 29 March 2017 provides as follows. Now, therefore, it has decided that the period of service rendered on actual contract or charge substitute period, which is followed by the regularization or regular employment without break or gap in service, except resignation, but notwithstanding the cases of resignation taken up with proper permission for another appointment, shall be treated as public employment and included in calculation of land of service for the purpose of pension under the Nagaland Retirement for Public Employment Second Amendment Act 2009. 23. On perusal of the aforesaid clause of the state office memorandum, it appears that the period of service rendered on actual contract or charge substitute period, which is followed by regularization or regular appointment without break or gap in service, shall be treated as public employment and included in calculation of that of service for the purpose of pension under the Nagaland Retirement for Public Employment Second Amendment Act 2009. It appears that though the contingency paid employees are not specifically mentioned in the aforesaid clause, however, as the petitioner was appointed to place a sanction post on a scale of pay without all admissible allowances, the nature of his service may be regarded as temporary in nature, and as he continued in his service without any interruption of the since 8/8/1970, that is the date of his initial appointment. This court is of considered opinion that he may not be deprived of the benefit given by clauses of the aforesaid memorandum. So, Lordship, when he retired when he died in 2002 and he retired in 1981, how would the only 2017 be applicable to the petitioner? As it would amount to discriminating the petitioner without any reasonable basis. 24. This court is considered opinion that the case of the petitioner husband is covered under clauses of the office memorandum dated 29 March 2017, and the respondent authorities were wrong in depriving the benefit of taking into consideration the period of service rendered by the husband of the present petitioner from 18/8/1970 to 1/7/1974 on the basis of Government of India's decision under Article 36A of the CSR Rule 14 by not taking into consideration of the period of service paid for contingency as qualified service for the pension. 25. This court is therefore of the considered opinion that the qualifying service of the husband of the present petitioner for the purpose of ascertaining his entitlement to pension shall commence from 18/8/1970 when he joined as contingency paid to machine in ascension pool with a scale of pay with all admissible allowances, and on doing so, the period of qualified service rendered by the husband of the present petitioner up to the date of his superannuation on 1/7/1981 comes to 10 years and 11 months, which is more than the qualifying service required for getting pension. The petitioner husband is therefore entitled to pension from the date of his superannuation, that is 1/7/1981, till the date of his death, that is 16/9/2002, and after the sick date, the petitioner is also entitled to get family pension. 26. The state respondent shall ensure that the pension of the late husband of the petitioner as well as family pension of the petitioner is fixed at the earliest by all retirement benefits of the husband of the present petitioner be released in favor of the petitioner within a period of 3 months from the date of the judgment. In view of the above discussion, this petition is allowed. So, Lordship, if you see the CCS pension rules, Lordship, we have adopted the CCS pension rules. So, if Lordship come to chapter 3, rule 13, rule 14, Lordship. Under Rule 14, there is a Government of India's order. Rule 14. That's your Lordship calling. Here it says, counting of service paid for contingencies with regular service. Under Article 368 of the CSR Rules 14, period of service paid for contingency do not count as qualifying service for pension. In some cases, employees paid for contingencies employed in type of work requiring services of full-time workers and are paid on monthly rates of pay or daily rates computed and paid on monthly basis and on being found fit brought on to regular establishment. The question whether in such cases service paid for contingencies should be allowed to count for pension, and if so, to what extent has considered in the National Council and in pursuance of the recommendation of the Council, it has been decided that half of the service paid for contingency will be allowed to count towards pension at the time of absorption in regular employment. So, Your Lordship, if a person served in a contingency, then only half of his service will count towards the length for the purpose of pension, Your Lordship. However, the learned simple judge has found all his contingency period and said that he has served 14 years and 11 months. Whereas, according to the state, he has served only 9 years, which is 1 year short to become qualified for pension.
What's the fundamental of the worship contingency? Should that be required a regularization? What do you say in 1974? He was promoted. That is, we can promoted can be only from a regular person. So that period from 1970 to 74, although projected as contingency, will have to be taken as being as temporary or regular. So 13 says, if it is temporary, that will come first qualifying. If it is followed by a regular service, that if it's 2017, that was specific for mention of that regular. 17, 70 to 81, we have more than 10. The delay in approaching persons, we can stop the benefits by the that we waste accidentally. Poor man will not even go there. There is a big difference. Another thing, once a rule is adopted, the decisions they will not from that employees of that rule. That also is not being adopted. The only adoption is with regard to the body of the rules. The decisions of the government will not come along. Only because it is there in the book, it will not come. It's not there in the book. Only the success is person with some other will not.
Madam, the government has said many things. One query. 1970, admittedly, he was a contingency.
Yes.
And as we understand a contingency, that is nothing.
Yes.
It's below a work charge, below a casual, it's nothing. Just for some work from a scheme you pay. So what is the system required? Contingency is not a regular incumbent in the cadre. Is not a regular incumbent in the cadre. So in 1970, how could you promote him?
No, we have not.
Yes, you have promoted him, madam.
It's not the order, it says that we have promoted.
No, he is promoted and temporarily appointed to the post of so and so. So that promotion, and that is also reflected in his so this is a promotion. The word used is promotion. You have not clarified that.
We have clarified.
Where have you clarified?
Page 94. Because this honorable court has directed us to obtain instruction on that. So page 94, Lordship. This is page 94, this is the letter. Honorable court's order dated 7/6.
Okay, fine. What is there?
So at 3, serial number 3. In this regard, it may be clarified that the order should have.
This is not something, madam. The person who issued the order may not be in this world. The person who received the order is not in the world. Now, from where have you? Order should have been.
So
Should have been is different, ma'am.
order should have been appointed as rate to DB and not as rendered.
Not as rendered, we understood, but it is promoted.
Appointed. It's a appointment.
So, madam, this word promotion,
Yes.
today, this was of 74.
So
Now, after around 50 years, you ask us to interpret that word.
Dobashi grade 2 is the lowest grade. It is the initial.
Be that as it may, he comes in from Dobashi, somewhere he was there.
No.
And okay, in spite of this word contingency,
Yes.
the engagement is for more than 1 year.
Yes.
Means it's not a time-to-time engagement, it's a continuous engagement. So we can deem it to be a temporary one, not a substantive, right? A temporary engagement against a post.
Yes, yes.
There is a post created.
Exactly.
Normally, contingencies are not appointed against posts.
But the appointment is not appointed as a Dobashi. Is appointed as a.
Madam, if you read further,
Oh.
from time to time with effect from so and so against the post newly created wide order dated to it. So this is not a appointment dehance a post. It's an appointment against a sanctioned post. So if it is an appointment against the sanctioned post, you come to 14. All these three conditions are satisfied. He was in a pensionable department. Service shall not qualify until duties are regulated by government. It is regulated by government. Service means service under the government and paid by the government from the consolidated or so and so or government, but does not include service in a non-pensionable. That is also not there. Belonging to who is permanently transferred to a service or post which applies the continuous service rendered under so and so in officiating capacity, so and so, because we'll have to understand it in the context that these rules were made for the central government concept. But coming to that, if you now come to 13, subject to the provisions, qualifying service of a government servant shall commence from the date he takes charge of a post to which he is appointed, either substantively or officiating or temporary capacity. Now, by noticing that you have promoted him and that contingent appointment was not the contingent appointment normally done where there is no post involved. This is a contingent against a particular post, a definition, a term was used. But with the promotion given, we say that it was a temporary appointment and then he was in the cadre. Contingents are not in the cadre. If you have to promote, you will have to be in the cadre. So from 70, he has it. Today, the clarifications given are not accepted. Another thing, madam, when did you adopt this CCS rules? When was it adopted in this state? 64, the state came into being. Thereafter, okay.
We have adopted.
64. Let us say 64. These office memorandums that you are dealing with is of 68 and 86. after the adoption. Where is your adoption of that also?
Document, but Lordship, we have also, that document I have.
No.
Whatever we have.
Means you say that we have adopted everything. Okay, on the date when you adopted whatever day you have adopted. But the things that have come subsequently, because it is there in Swami's handbook, will not make it attractive to you. Because there may be, madam, things which you may not want to adopt. But if we pass that order, that, okay, we dismiss the case of the respondent, the respondent here, and say that because this is there, they have adopted. Tomorrow there may be provisions therein which you may not like to follow. You will be in trouble. A poor man, poor lady before this court, why these big technicalities? We will not go by that 2017 thing. We will not go with that.
But if you see that section 2C says that the 60th pension rule does not apply to specific for contingency. So only from 1974.
Now, what is contingency then?
Yes.
What do you understand by the term contingency? It is a purpose.
Yes.
So it is not against any post.
Yes.
It cannot be against. It cannot be. No, because if the post is there, the money is coming from the budget. It's not a contingency for some scheme. Normally, madam, contingency means some scheme, temporary, some work is there, you are paying him. But when the money is coming from the government, it cannot be contingency. That's why the term contingency here is misleading. How skin of thing? Everything. And post we do. A 226 court cannot be that oblivious of a condition of a man.
That's my case, Lord. I say that.
Sir, what do you say? Why should you be paid? No, forget my saying that was for her. Now, what about you?
First issue is, he was a Nagaland developer. That is under the government of Nagaland. Then he was appointed. It is not he alone. It is 16 threshold. And it is a case created by authority of the government, not is any consequence. After that, this court was taken note of their own OM dated 26 November.
How will that OM be applicable with retrospective effect? Where is that OM? Here?
One of the page 72.
This also does not apply to him, Lordship, because it's 2009 and he retired in 1981 and he died in 2002.
And where is that 2017?
2017 is over a more time. This is from the government.
Madam, this is not a standalone office memorandum. This is a clarification. And if it is a clarification, it will go. 2009, if you come to page 72, many departments have sought clarification as to whether the services rendered by an employee on so-and-so should count for fixing the length of their service. Now, madam, this is again a decision going against your rules.
In which para you are right?
73.
Page
Page 73.
Hmm.
72.
No, 73 is the type copy. Many to so and so, so and so. Hmm.
Yes, Lordship, where will you regularize his service? But here in this.
No, ma'am,
case,
no.
yes,
You regularize his service from the date of regularization. Now I am on the strict interpretation application of rules of 1972. Now, from the date of your regularization, okay, you are a government servant. You are covered by 1972 rules. Now you say, you have the power. You say that no, even the period prior to that, we are now considering as your qualifying service for pension. Now, if you come to Rule 2, application of 1972 rules, it excludes persons in casual and daily rated. So, if this is 2009 you are adopting, how do you connect it with 68 and 86 circulars under Rule 14? Where is the thing that you have superseded that? You say that we are following the circular's decision under 14,
Yes,
Government of India, 68 and 86. So now this is 2009, admittedly afterwards. So where is that reference? 50%.
For this matter, if a person is in contingency and he has been regularized against a post, then this will apply. But what are
This is the first time you have applied it, that 68 and 86. It's not there. You have not adopted it. Otherwise, why this 2009? If 68, 50% comes in, because you cannot say that that period will not be taken. You say that we will go by the Government of India decision. 50% we will take. 3 years, it will be 1.5. 7 plus, it will be around 8 years till you don't come in.
So for this matter, Lordship, we want to see that what is the law at that point of time when the petitioner retired?
No, madam. No. If you are adopting 68, 50%, and this is the decision, how to do it, then you clarify that from today onwards, it will not be 50%, it will be full. So this being a clarificatory one, it will go back.
We have the Professional Service Rule, where 2 is a direct recruitment. So Lordship, we appointed him.
Those are not the pleadings, not the pleadings.
But the first appointment, na, we have to see the first appointment.
So this adoption of Government of India decisions would be dicey for you, because there would be decisions which may not be in the interest of the government. They may not want to adopt it. So if you take that stand, tomorrow you may be in trouble in some other case. So we're not going to all this. We'll say, poor man gone, give him. We'll uphold the decision. And with regard to your objections with 2009 and 2017, we'll only say we are not interfering, but only clarifying. These 2 OMs being clarificatory in nature will have a retrospective effect. We'll finish it off. I can pass it. Dispose it off. You're disposing it off. You'll get the order by Friday or by Monday. Disposed of. You have that one.
For unlisted motion, item number 32.
Three matters. I thought 1 matter. 3 matters at first.
Preventive detention.
All preventive detention matters.
Yes, ma'am.
Oh, you said 1. So now we have 3. Matters grew by the time it was listed.
Is the respondents and not accepting the copies?
Okay, no problem. Miss, she's in government. Madam Sukri, you can accept the notice. This is, or you can tell me who will accept. We can write down that. Okay. Heard, Mr.
I am junior.
I am junior. Also heard Miss, what was her name?
AIME.
AIME, learned government advocate, appearing for the respondents number 2, 3, and 4. And for the union, who will, Mr. And also heard Miss N. Nuli, learned CGC, as well as Miss So-and-so, learned state, learned government advocate, full stop. Issue notice, returnable when? 3rd June. Okay. Okay, on 3/6/2026. So-and-so, Ms. N. Nule, learned CGC accepts notice on respond number 1, while Ms. So-and-so, a learned government advocate, accepts notice on behalf of respondents number 2, 3, and 4. No formal notice is to be issued. Before the next date of listing, the respondents shall file, invariably being on record their stand by way of filing an affidavit. The learned state council shall also produce the records in original for perusal by this court. Registry to list this matter again on 3/6/2026. Same order in the other 2 cases also. The parties are same?
No different copies.
Okay. Show me.
But about some of the documents.
No. The numbering of the parties are same. Same. 2. Next one. Same, madam.
Lord, I'm not clear. I would not find the authorization letter, the original document.
File an addition.
Why would I have to do it? I need to allow it.
You file it, we'll see. We'll see. Madam. Just a moment. Come, we can come to segment. That all suggestion that is being delivered today. Even free. Just give a count out. Thank you.
for hearing item number 1.
Nothing to add. Heard Mr. Lima Wapang, Learned Counsel for the petition. Also heard Mr. I. Imsam, Learned Additional Advocate General, appearing for the respondents number 1, 2, and 3. And Madam, your name? Ravi, when Learned, just take down their names. Learned Counsel appearing for the respondent number 4. The next, the petitioner in the present petition, please have your seats, please, has presented a challenge to the selection and appointment of the respondent number 4 against the post of sweeper in the establishment of the additional deputy commissioner, Pugho, P-U-G-H-O-B-O-T-O. So the petition on the ground that the petitioner, that the respondent number 4 was not an indigenous inhabitant of the district in question. The facts in brief requisite for adjudication of the issue arising in the present petition is noticed as under 3 QDB 3.1. The commissioner Nagaland, Kohima, had issued an advertisement dated 17/1/2018 inviting applications for filling up of various grade 3 as well as grade 4 posts available in different district establishments. So, the said advertisement was also so made for recruitment against a grade 4 post available in the office of the Deputy Commissioner, Pugo Buto. In terms of the eligibility criteria set out in the said advertisement, an applicant should be an indigenous inhabitant of the district and within the the petitioner, in pursuance to the said advertisement, submitted her application for recruitment against the post of grade 4 available in the office of the district commissioner, district deputy commissioner, Fugobutu, deputy commissioner, Fugobutu. No, she was posted against that, but the establishment is of the deputy commissioner.
Yeah, the establishment of the deputy commissioner,
Zenebuto. And what is this Pugoboto?
Subdivision.
Okay, eto likha. Also, establishment of the additional deputy commissioner Pugoboto day. I got deputy commissioner no. Huh? Full stop. The respondent number 4 had also submitted her application against the post, against the set post. Had also submitted her application against the set post. So thereafter, thereafter a selection was held in the matter, and a select list came to be published on 28/2/2019. In the select list so published, the respondent number 4 was placed at serial number 1, while the petitioner was so placed at serial number 2 on merits. So, in terms of the selection of the petitioner, of the respondent number 4, the additional deputy commissioner Fugobuto, Nagaland, proceeded to appoint the petitioner as a sweeper in his establishment. Full stop. The petitioner, being aggrieved by the appointment of the respondent number 4, submitted a representation dated 13/8/2019 before the additional deputy commissioner Fugoboto, and therein required the cancellation of the selection and appointment of the petitioner on the ground that the respondent number 4 day was not a indigenous inhabitant of the district in question. Also, the said prayer of the petitioner not being considered, the petitioner had approached this court by way of institution of a writ petition being WPC number 138/2019. However, in view of the fact that in the said writ petition, the indigenous certificate obtained by the respondent number 4 was not challenged, the petitioner prayed for withdrawal of the said writ petition with liberty to refile the same. This court, while order dated 19/9/2019, permitted the writ petitioner to withdraw the said writ petition with liberty to refile the same. It is to be noted that one Kakuto Sheki, page 33, Pavia, had also approached this court by way of instituting a writ petition being WPC number 125/2019, assailing the selection and appointment of the respondent number 4 herein. A coordinate bench of this court, while order dated 16/8/2019, had, while issuing notice in the matter, suspended the order dated 18/1/2019 issued towards appointment of the petitioner of the respondent number 4 against the post of sweeper in the establishment of the additional Deputy Commissioner Fugoboto. After the present writ petition was so instituted and notices issued therein, the respondent authorities issued notices to the issued an order dated 10/12/2019 to the respondent number 4 herein, requiring her to establish that she was a person belonging to the scheduled tribe and was an indigenous inhabitant of Nagaland. The thereafter, while an order dated 10/12/2019, issued by the additional Deputy Commissioner Fugoboto, the indigenous inhabitant certificate issued to the respondent number 4 came to be cancelled. Being aggrieved, the respondent number 4 approached this court by way of instituting a writ petition being WPC number 194/2020. A coordinate bench of this court, while issuing notice in the said writ petition, was pleased to stay the effect and operation of the orders impugned therein. Thereafter, the said writ petitions being WPC number 176/2019, filed by the petitioner, instituted by the petitioner herein, and WPC number 194/2020, instituted by the respondent number 4, were taken up for final consideration analogously. On such consideration being made, the coordinate bench of this court, while judgment and order dated 4/3/2022, was pleased to dismiss the writ petition preferred by the petitioner hearing, that is WPC number 176, dismiss the present writ petition, that is WPC number 176 2019, while proceeding to allow the writ petition being 194 2020 preferred instituted by the respondent number 4 hearing. After disposal of the said writ petition, the coordinate bench of this court directed the respondent authorities to inquire and verify with regard to the indigenous inhabitant status of the respondent number 4. Full stop. The petitioner hearing being aggrieved by the said judgment and order dated 4/3/2022, assail the same by way of instituting a writ appeal being WA number 3 of 2022 before the division bench of this court. The division bench of this court, upon considering the issues arising in the present writ petition, was pleased by judgment and order dated 2011-2025 to interfere with the judgment and order dated 4/3/2022 passed by the learned single judge in WPC number 194/2020, 176/2019 and 194/2020, and had remanded back the matter for a fresh consideration. It is accordingly, the said writ petitions were restored to its file and listed before this court for consideration. Full stop. A further factor would be required to be noticed by this court is that the additional deputy commissioner Puga Boto, in pursuance to the inquiry carried out by him in the matter, had wide notification dated 25/4/2023 held the respondent number 4 to be not a indigenous inhabitant of Nagaland and the indigenous inhabitant certificate indigenous inhabitant dated 14/6/2013 was cancelled. The petitioner, the respondent number 4, being aggrieved, had assailed the cancellation of our indigenous inhabitant certificate by way of instituting a writ petition being WPC number 296/2023. Full stop. Oh, it got remanded back position 176/2019. The other one was not remanded back. That was not remanded. Full stop. More correction going. Remanded back. Full stop. Full stop. The writ petition being WPC number 296 2019, which was being considered along with the present writ petition, was, however, on the prayer of the respondent number 4, permitted to be withdrawn by this court wide order dated 14/5/2026. Full stop. Full stop. I've heard the learned counsel for the parties have reiterated the facts noticed herein above. Full stop. The learned counsel for the petitioner has submitted that the challenge made to the cancellation of the Indigenous inhabitant certificate in the proceedings of WPC number 296 of 2023 on its withdrawal. The learned counsel for the petitioner submits that on the withdrawal of the petition filed by the respondent number 4, that is WPC number 296 of 2023, the cancellation of the Indigenous inhabitant certificate so affected by the order dated 25/4/2023 issued by the Additional Deputy Commissioner Fugo Boto stands revived. He submits that the respondent number 4 accordingly cannot be held to be an eligible candidate for recruitment against the post of a grade 4 post as advertised by the advertisement dated 17/1/2018. The learned counsel for the petitioner further submits that the name of the respondent number 4 would now be required to be deleted from the select list published in the matter, and on such deletion, it would be the petitioner herein who would be placed at serial number 1 on merits. So accordingly, it is prayed that the respondent authorities be directed to appoint the petitioner in terms of a select merit position obtained in the selection process. Mr. I. Imsok, learned Additional Advocate General, has not disputed the facts noticed herein above, but has made a submission to the effect that the select list published earlier had a validity of only 6 months, and on the lapse of 6 months since the date of publication of the select list, the same cannot be directed to be implemented. He submits that the post in question would now be required to be filled up by instituting a fresh selection process. Next. Ms. Swan's learned counsel for the respondent number 4 submits that the writ petition being WPC number 296/2023 having been withdrawn by the petitioner, by the respondent number 4, she would have no, and the same having revived the cancellation of her Indigenous inhabitant certificate, she would now be any further eligible for consideration of her case for appointment against the post in question. Also, I've heard the learned counsel for the parties and peruse the materials available on record. As noticed herein above, in pursuance to the judgment and order dated 4/3/2022 passed by the coordinate bench of this court in WPC number 176/2019 and 194/2020, the Additional Deputy Commissioner Fugo Boto, had proceeded to carry out a verification process with regard to verification process to ascertain the Indigenous inhabitant status of the respondent number 4. The said on conclusion of the said verification process, the Additional Deputy Commissioner Fugo Boto, by a notification dated 25/4/2023, proceeded to hold that the respondent number 4 cannot be considered to be an indigenous inhabitant of Nagaland, and accordingly, the indigenous inhabitant certificate issued to the petitioner came to be cancelled. The petitioner had assailed the said cancellation by way of instituting WPC number 296/2023. However, as noticed here in above, the said writ petition was withdrawn by the respondent number 4 herein. So accordingly, for all intent and purpose, the respondent number 4 cannot be held to be an indigenous inhabitant. Full stop. Having noticed the said position, this court would refer to the advertisement dated 17/8/2018 to understand the requisite eligibility criteria for being eligible to apply against the post advertised thereby. Full stop. For the eligibility criteria for grade 4 as set out in the advertisement being relevant is expected here in below. Clause 4, page 18, clause 4, A to A. Page 18. मैं तो my ID should 4 लिखा है पूरा my ID भी A to A. So, a perusal of the said eligibility criteria would go to reveal that an applicant desirous for applying against a grade 4 post must be an indigenous inhabitant of the district concerned wherein the post against which such application is proposed to be submitted exists. The petitioner as well as the respondent number 4, in pursuance to the application submitted by them, had appeared in the selection process, and in the select list as published, the name of the petitioner of the respondent number 4 was placed at serial number 1, while that of the petitioner was placed at serial number 2, basing on the merit position obtained by them in the selection process. However, with the cancellation of the indigenous inhabitant certificate granted to the petitioner, granted to the respondent number 4, she is to be held to be not eligible for even being considered against the post in question. Accordingly, the placement of the petition respondent number 4 in the select list at serial number 1 would mandate an interference. So, accordingly, the placement of the respondent number 4 at serial number 1 stands set aside. With the setting aside of the name of the respondent number 4 from the select list in question, it would now be the petitioner herein who would be so placed at serial number 1 in the select list. Full stop. The said conclusion, accordingly, now the select list being required to be so construed with the petitioner being being placed therein at serial number 1, this court would consider the submissions made by Mr. I. Imsong, learned additional advocate general appearing for the state respondents, that the select list originally prepared had a validity of only 6 months, and they say, and after lapse of 6 months, the select list cannot be held to be validly cannot be held to be existing. This court notices that although the said select list was so published and may have had a validity of 6 months, the same was under challenge before this court proximate to the time the same was so published. Full stop. the said select list being subjudiced before this court proximate to the time it was so published, this court holds that the said select list cannot be held to have lost its validity and the said select list continued to remain in force during the pendency of the earlier proceedings as well as the present writ petition. So accordingly, the petition are now being placed at serial number 1, the respondent authorities, more particularly the additional deputy commissioner is a party. More particularly, the additional deputy commissioner, Huga Boto, Zune Boto, that is the respondent number 3, is directed. Respondent number 2 and 3.
Since respondent number 1 hasn't found it.
Okay. The respondents number 1, 2, and 3 are directed to appoint the petitioner against the post of sweeper available in the establishment of the respondent number 3 within a period of 2 months from the date. Within a period of 1 month from the date of receipt of a certified copy, by reckoning that the petitioner herein is the candidate presently placed at serial number 1 in the connected select list. So, nothing more. With the above observations and directions, the present writ petition stands disposed of. So I do a draft of my idea. You'll not get it tomorrow, but before I go, I'll sign it.
No problem.
Get this file to them. Only bit 176. Kuriate he Ankor order will so be at a price at this you keep it. Okay. Thank you.